thank you everyone for joining us today. My name is Jiyae Hwang. I am a senior associate at Scott Legal PC. Today, we're going to spend some time talking about the visa options available for individuals with extraordinary ability in their fields. So just a few things before we get started. Scott Legal is a full-service immigration law firm, which means we do have expertise handling a wide variety of non-immigrant and immigrant visa categories suited for various circumstances. So whatever your immigration needs may be it a family-based, employment-based, or an investment-based immigration matter, we can help you find a solution that works for you. We will be continuing this webinar series, and we are doing at least 2 webinars a month on a variety of different topics related to immigration law. And at the end of this webinar, we'll be sending out a few resources to all participants. First, we will send you a copy of the PowerPoint that will be used in this webinar today. Second, we will send you all a visa guide, which is a comprehensive guide that you can use as a resource that covers the visa categories that we will be speaking about today. We will also send you a link that you can follow where you can you can sign up for additional webinars that are coming up in the future, and also a link to this webinar as it will be recorded. This webinar will also be made available on YouTube, and we do encourage you to subscribe and hit the notification button as we do regularly upload a variety of immigration-related videos. We will also send you a link that you can follow to set up a consultation with one of our experienced lawyers should you wish to discuss your case further. So today we are very lucky to have Kelly Weiner, who is a partner of the firm with a wealth of experience handling cases in the visa categories we will be speaking about today, who will be presenting about these various options available to extraordinary ability individuals and the requirements and considerations for those visas. Finally, for any question you may have, please feel free to add them to the chat box or the Q&A function, and we will try and get to all questions. So without further delay, I will turn it over to Kelly.
Thank you, Jiyae. So we're going to get started today just talking a little bit about some of the most common extraordinary ability visa categories. These are both temporary visas, so visas that you can get if you want to come to the United States and work for a few months or a few years, and then also a green card for people who want to come and live and work in the United States on a permanent basis. All right, so let's talk about the O-1A visa. So this is a temporary visa, also called a non-immigrant visa, for people with extraordinary ability in the sciences, education, business, or athletics fields. And the standard for this visa is a person who has risen to the very top of their field. This is really not a visa for people that are kind of more entry level, more starting out in their careers. This is for people that can show they're one of a small percentage who are at the very top. So then there's the O-1B visa. So this is another temporary visa. And this visa is for people with extraordinary ability in the arts. And then also there's another category for people of extraordinary ability in motion picture or television industry. And there's kind of slightly different standards for each of these. So for the arts, the person must have achieved distinction. This means a high level of achievement, substantially above that ordinarily encountered, and the person must be known as prominent, leading, or well-known in the field of arts. So we can see that this standard is different and slightly lower than the standard for the O-1A. So there are some times where somebody's, industry may be, may not be clear. Like, is it business? Is it arts? For example, tattoo artists, sometimes there's kind of sommeliers or people doing like important things with kind of bartending. So in these kind of niche or kind of emerging fields, sometimes there's an option whether to go with O-1A or O-1B. And if you do have that option, it can be helpful to try to go with O-1B just because the standard of distinction, it can be a bit easier to meet. Excuse me. And the standard for motion picture and television industry is higher than for arts. The applicant needs to show they've reached a level of acclaim substantially above that of his or her peers. So then we'll turn to the EB-1A green card. So this category is for people who want to live and work in the United States permanently and make the United States their main residence. So once you have a green card, it is required that you primarily live in the United States. Any trips outside the US that are longer than 6 months, can be problematic. Any trips longer than a year, your green card becomes invalid. So when you're thinking about which category should I apply for, you want to think about, what is my intent? Do I want to be in the United States, long term and permanently? Am I okay spending long amounts of time in the United States, filing taxes there, things like that? If not, or if you're still deciding, a temporary visa may be a better option. All right, so and then the EB-1A green card, just going back to that quickly. So this is for individuals with extraordinary ability in the sciences, arts, education, business, or athletics. So whereas above, we've separated out the arts and motion picture and TV between O1A and O1B. For the EB-1A green card, it's all just one category, and the standard is the high standard of you have to be one of a small percentage who've risen to the very top of your field of endeavor, show sustained national or international acclaim. Your feats have been, recognized in your field of expertise, and you plan to continue working in that area of expertise in the United States. So for the O1A and the O1B, this is going to mean that we'll talk a little bit more about timing later, but for the full amount of time you want to be in the US, like let's say you have a tour, you have a year full of tour dates. So then you're going to get the visa for 1 year for the amount of time that you can show you have extraordinary ability work lined up. Whereas for the EB-1A green card, since this is kind of a permanent green card, you're going to live in the US, you're going to submit a statement that kind of outlines what you plan to do in the United States. And if you have objective evidence supporting what you plan to do, you can submit that as well. For one last one we'll talk about briefly here, and then in the second part of the presentation, Jiyae will cover this in a lot more detail, is the National Interest Waiver Green Card. And this is really not thought of usually in the same category as extraordinary ability. It's kind of adjacent to extraordinary ability. Sometimes people who may not have reached the EB-1A standard where they're, at the very, very top of their field, may still qualify for the national interest waiver with their really elevated profile that maybe doesn't quite reach EB-1A, but is still very impressive, as long as they're engaging in an endeavor of substantial merit and national importance to the United States. So if you can demonstrate you meet the EB-2 threshold requirements, which is master's degree or higher or exceptional ability in your field, and then that you are engaging in an endeavor of substantial merit and national importance, that you yourself are well positioned to advance that endeavor, and that the United States, on balance, it's beneficial to them to waive the normal requirement of the EB-2, which normally requires a labor market test. So all of those factors go into a successful national interest waiver green card application. This green card, so it's permanent. You can live in the United States and work, and you also need to be planning to advance this endeavor. That needs to be part of the application. All right, let's move to the next slide and talk a little bit more about the O1A visa. So the O1A, you have to demonstrate that you have either received a major internationally recognized award, such as a Nobel Prize, or much more commonly, people are submitting evidence of at least 3 of the following. So receipt of nationally or internationally recognized prizes or awards, membership in associations in your field which require outstanding achievements, published material in professional or major trade publications, newspapers, or major media about you and your work in the field, original contributions of major significance in your field, any authorship of scholarly articles in professional journals or major media, a high salary compared to others in your field, participation in a panel as a judge of the work of others, and employment in a critical or essential capacity for organizations that have a distinguished reputation. If none of these are applicable to your field, or if not, all of them, not at least 3 are, you can also try to argue, other comparable evidence, but it can be somewhat hard to do because you would have to also demonstrate why you weren't able to provide these other types of materials. Something to keep in mind when you're looking at this is that it's not a good idea to just include every single award you've ever won. You want to be strategic about what evidence you're submitting and only submit evidence that shows that you are someone who's risen to the very top of your field. So if you received like a student prize, in college, that's not really going to be helpful. If while you were in college, you competed in a very prestigious global competition and you won, that award, that you would want to submit. The fact that you were a student while you won it, doesn't hurt you, but student awards wouldn't work really, whereas that type of award would work. You want to think about what evidence do I have that the award I've won is nationally or internationally recognized? What other prestigious, like markers are there for this type of, of prize or award? Because, and we'll talk about this a little bit more later, ultimately what they'll do is they're going to look at all the evidence, and then they're going to consider, does this evidence, first, have you submitted proof of prizes or awards? Okay, great, we see that. But then when we're looking at this all together, does this demonstrate that this is somebody who's risen to the top of your field? So if you're including everything, including things that are really not meeting that criteria of, so maybe it's a membership in a professional association, but basically anybody who, let's say it's a lawyer, anybody who's a lawyer can join this professional association. If they're a lawyer, they pay a yearly fee. That type of membership is not very helpful. You want a type of membership where there's actual achievements that you need to have met in order to qualify, where perhaps you need to be invited based on things that you've done in the industry, where there's other prestigious people in your industry who are members who also had to pass that strict criteria. Those are the things you want to be thinking about when putting together your application. All right, so O1B visa. So very similar in structure to the O1A. So you're demonstrating either that you were nominated for or received a significant national or international prize or award, an Emmy, a Grammy, or again, much more commonly, evidence of 3 of the following. So I'm not going to read all of these out. They're here on the slide, and you'll also get them when you receive the copy of the PowerPoint. But essentially, these are very similar to the ones I just read out, except they're focused on the arts, what would be relevant in the arts, right? Performing a lead or starring role in a production or event which has a distinguished reputation. So you want to look at each of these and see which ones would be, you want to, 3 is the minimum, but obviously as many as possible is what you want to submit. And then it's the same strategy as with the O1A, where you really do want to think about, not including, even if there was great reviews of, something you did when in your high school play or something like that, you really want to be thinking strategically and talking to your attorney to see, is this evidence I'm going to submit? Like when they review the totality of the evidence, is it going to hurt me if what they're remembering is, oh, that one piece of evidence really wasn't that strong? All right, so O1A and O1B, let's talk about some of the differences. So in terms of the fields, we know that there's differences. O1A is science, education, business, or athletics. O1B is the arts and the motion picture or television industry. As discussed, there are some fields that don't neatly fit into one category or the other. And so that would be something where you would discuss with your attorney and figure out strategically, what is the best, path to take here? Where can I make my strongest arguments? The standards are different, as we mentioned. So the O1A is a higher standard, one of a small percentage who've risen to the very top of their field of endeavor, whereas arts is distinction, and motion picture or television is a level of acclaim substantially above that of their peers. They're all issued for the same length of time, so you can get an initial visa for 3 years. You can get extensions if you're just extending, like you had an itinerary and you need to finish it out, you're just extending that current, itinerary, then you can get an extension for 1 year. If you're taking on new employment, if you're taking on new projects, you can ask for an additional 3 years, whether even if you're doing an extension through USCIS, but you do need to demonstrate that you have that new set of projects. And your family can come to the US with you. They can get dependent visas for your spouse and any unmarried children under 21. Your spouse is not permitted to work, but both your spouse and your children can attend school and stay with you while you're in the United States. All right. So for the EB1A green card, as we discussed, this is the permanent, option. So this is the option for people who say, yes, I want to live in the United States, and work in the United States full time, make this my main domicile. And the requirements are very similar to the O1A and O1B. They encompass both, since arts is, folded into the EB1A. So there's not separate categories like there are for O1A and O1B. And here we're going to discuss a little bit about the Kazarian analysis. So this is where, as I described earlier, when you're putting together your evidence, first you're looking to see what is the plain language of the requirement. So, okay, I need to have prizes and prizes and awards, nationally or internationally recognized prizes or awards. Can I demonstrate that? Okay, great. Here I have this prize. So you're going to go through that analysis with each piece of evidence, put them all together. And USCIS is going to look at all of those and see, okay, do we have at least 3 criteria? Do we have at least 4 criteria met? But in the second step of this analysis, they're going to look at the quality of the evidence in totality. So they're going to say, okay, when we look at everything this person has submitted, what is our final determination? Are they someone who is among the very small percentage of people who've risen to the very top of their field? So that's where we go back to what I've been saying previously. That's where you don't want to have them reflecting on, well, they submitted 8 awards and 5 of them were really strong, but then they had those 3 student awards. So that's where you can see, it's better to submit 5 really strong awards, or even 2 really strong awards than it would be to submit that with evidence that's going to weaken your case when they look at everything in totality. So that's an important thing to keep in mind about the EB1A and then also about the O petitions. I think some people have the impression that if you just give them every single thing you've ever done, going back, as far as you can, that is going to, make the petition more successful. And it's really not the case. All right, so we're going to turn now to the national interest waiver, and Jiyae is going to walk us through this category.
Great, thank you, Kelly. So yeah, let's talk about the national interest waiver. And as Kelly mentioned, it is a green card option. It is a part of the EB2 category. And that means once you're successful in this application, you would get the right to permanently reside in the United States. So it is well suited for people who want that. One thing to note is that every individual who applies for the NIW must first meet the EB2 threshold requirement. And this is a minimum before we go into the NIW criteria, which is listed below. So how do you meet the EB2 category? So either the applicant needs to show that they have an advanced degree or its equivalent. So an advanced degree is defined as a master's degree or higher. So for example, a PhD would certainly apply. An MBA also would count as an advanced degree. A JD or an MD, for example, also count as an advanced degree, even though they're not technically master's degrees, because you typically need a bachelor's degree before you can gain admission to those kinds of programs. Now, if you don't have a master's degree or above, and if you have a bachelor's degree in your field, and if you have more than 5 years of work experience that has progressively gotten more senior over time, you can actually use that to be qualified as an equivalent of an advanced degree holder. So if you have a bachelor's degree in, engineering, for example, and if you have accumulated 5 or more years of progressive work experience after you received your bachelor's in engineering, and if you can prove by things like, employment confirmation letters from your previous employers, proving that you have had that full-time experience and proving, describing how your duties change over time, such that they became more complex, maybe your salary got higher, maybe your job title became, different, like, associate engineer to senior engineer, for example, that really shows the progression upwards. And if you can show that, then you could meet the EB2 threshold through showing that you have an equivalent of an advanced degree. Now, another thing to note is that if you received your advanced degree in a foreign institution that is not a United States university, then you should also plan to get a what is called a U.S. Education Equivalency Assessment from an accredited U.S. evaluator, because the government wants to know that your advanced degree that you got from the foreign country is equivalent to the same level degree in the United States. Now, if you don't have the master's, if you don't have the bachelor's, or if you don't have the 5 years of experience, then perhaps you can meet the EB2 threshold in an alternative way, which is by showing that you have exceptional ability in the sciences, arts, or business. Now, in order to meet exceptional ability, you need to meet at least 3 out of the 7 evidentiary criteria listed below. So this includes things like a relevant degree in your field, even if it's not a bachelor's or even if it's not a master's. For example, an associate's degree, for example, could also work. If you have any licenses or certificates that is related to your field of exceptional ability, you can provide that as evidence. If you have 10 years of full-time experience, and if you can prove that through, letters of confirmation by previous employers and things like that, that is also another evidence you can submit. If you receive a high salary as compared to others in your field that, in a way that shows your exceptional ability, that is another type of evidence. Membership in professional organizations. And what is really important is, can you show that you have received recognition for your achievements by your peers in the industry, by government actors, or other leading organizations in your field? And evidence of such recognition could take various forms. Like, for example, were you featured in a newsletter in your industry publication, for example? Did you have you made any innovative inventions, and have you published a patent under your name? Things like that. And has these patents, or have any articles that you publish, gained a high number of citations? Those are some of the several ways that you can show that you have received recognition by your peers for you having this exceptional ability that sets you apart from, what is ordinarily found in the field. So it is definitely a lower standard than extraordinary ability, which is what Kelly has described in earlier slides, which requires you being in the very, very top of your field, being one of the small percentage who have reached the very top. However, by contrast, meeting the exceptional ability threshold for the EB2 NIW is quite a bit of a lower standard. So holistically, what the evidence need to show is that you have a degree of expertise that is, quote unquote, significantly above what is ordinarily encountered in the field. So if the body of evidence that you can provide really proves that, then exceptional ability could be an option for you in meeting the threshold. Now, if you met the threshold, if you can show that you meet the EB2 threshold, the next step is to demonstrate that you do qualify for the national interest waiver. And to provide a little bit of context, the national interest waiver exempts you from going through what is called the ordinary labor certification requirement, right? So ordinarily, the EB2, if someone is applying for an employment-based green card on the EB2 category, what you need is a U.S. job offer, and you need a U.S. company to sponsor you, and that U.S. company sponsor also needs to go through a very complicated process where they test the labor market and show that there is no other U.S. worker who is has the minimum credentials and is available or willing to take that job. And only after you certify that, then the U.S. sponsor can sponsor the beneficiary for the green card. Now, the NIW completely exempts all of that if the applicant can show the 3 matter of Danaher criteria that is listed below. And that gives a significant advantage, because that means the applicant does not need a U.S. job offer. The applicant does not need a U.S. sponsor to become the petitioner of the petition. Actually, the foreign national themselves can self-petition for an EB2 NIW, and that is a very important distinction for that category, EB2 NIW, as opposed to other available categories out there. Now, the EB1A also is a category that allows self-petitioning. So if you're an individual who doesn't have a job offer, who doesn't have, a U.S. company to sponsor them, they can also choose the EB1A option. Now, however, the thing about the EB2 NIW is it could be more relevant and accessible to a wider variety of professionals in a more wider variety of professional, in their journeys, because for the EB1A, you really need to have reached the very, very top to be approved. But for the EB2 NIW, the considerations and eligibility, criteria is a little different. So it could be more accessible considering your circumstances. Now then, let's go through the 3 matter of Danaher 3-prong criteria and talk a little bit about what they entail. So the first requirement is that the applicant must prove that their proposed endeavor in the United States has both substantial merit and national importance. And what does that mean? So substantial merit can be proven in a wide variety of fields, including business, health, education, science, technology, and endeavors that tends to further human knowledge in these key areas, such as endeavors that result in medical advances, endeavors that result in improvements in civil engineering practices, for example, can be favorable for substantial merit and national importance. Now, when you are trying to prove national importance, it is one way to prove that is to show a strong economic impact. And so really the question that you want to answer is, what is the future impact of your, potential work in the United States, your planned work in the United States, and how is that important to the United States? What arguments can we make in support of that? So, for example, if the United States government has released certain reports talking about why certain areas are important to the United States economy or national security, such as, developing AI industry or developing cybersecurity or developing, clean energy infrastructure, for example, if the government has reports talking about these things, perhaps you can link those reports and provide a proposed endeavor that explains why your particular work, your specific work in the United States can help significantly advance those priorities. And if you can prove that your work has the potential to really make a difference in those priority areas, then you could have a good case for substantial merit and national importance. Now, the second requirement is that the applicant must prove that they are well positioned to advance the proposed endeavor. And what does this mean? This means you would look at your education, you would look at your experience, you would look at what is your previous record of success in previous related projects that is, that is directly relevant to the proposed endeavor that you are arguing, right? So you can, get expert letters talking about, some of your projects that you've led in the past and what was the impact of those projects. And those kinds of, previous case studies can really help the argument that you're well positioned to do this important work because you have done similar things in the past and they have been successful. The third requirement is that, on balance, there must be a showing that it would be beneficial for the United States to waive the requirements of a job offer and thus of a labor certification. And that goes to the point that I was making earlier, where ordinarily employment-based, immigration petitions are based on a U.S. job offer and is based on testing the U.S. labor market to see if there is a U.S. worker who can fill your position. Now, you must show that the potential benefits of your work and your presence in the United States is so much greater than the ordinary benefits of, really securing the U.S. labor market, right, for U.S. workers. So you can approach this in a variety of ways. You can talk about the outside benefit, the broad benefits that your work can have to the field because you're, providing innovations to a particular technological area, for example, that can really have a lot of ripple effects in the industry. You can argue that. Another thing you can talk about is if you have unique and advanced skills that cannot, necessarily be replaced by another U.S. worker with minimum credentials, maybe you can emphasize that and saying that, you're maybe one of the few individuals in the world who has knowledge in this particular area. And so if you just get another U.S. worker with minimum credentials, you may not, have the advantage of these advanced skills. So that's another thing you can argue. If you're an entrepreneur, another argument you can make is that if you have a business endeavor that is potentially going to create dozens of U.S. jobs in, an area that is really in need of revitalization, such as economically depressed areas with a high unemployment rate, if your business plan contemplates hiring a high number of workers in that area, then you can, really argue that on balance, your work has, outsized merit because it will create such high number of jobs in those targeted areas. So there are various ways that you can approach this third prong. All right, so one important thing to note is the role of expert opinion letters in extraordinary ability petitions. And expert opinion letters play a very important role for both O1 petitions, EB1A petitions, and NIW petitions. And the purpose is a little different for, depending on what category petition you are arguing for. So for example, for the EB1A and O1A, O1B, you would want the experts to confirm that you have extraordinary ability in the field and is well known, and describe what are your achievements that that you have been well known in the industry for. So explain what you do that is different from the vast majority of other professionals in your field, such that, really proving that you have sustained national and international acclaim in the case of O1A and EB1A, for example, to help meet, that criteria. Regarding the NIW, the letters can take on a little bit of different form based on what you're trying to prove. So, for example, if you're trying to prove national importance and substantial merit, you can maybe get a letter from a particular government agency, an officer who works with the government, who can confirm that a certain area is in the national interest and also describe how your specific endeavor significantly advances such national priorities. And having a government affiliated letter can really help in an NIW case in particular. So a little bit of different strategy can work best depending on the category that you're using. Other types of NIW letters can talk about the applicant's contributions in the field, such that it'll help prove that they are well positioned to advance the endeavor. So those types of letters can come from previous employers, for example, confirming the applicant's leading role in a particular project that resulted in a broad impact to the field, such as the development of new technology or research projects that ended up improving the best practices of a field as a whole. If you're an entrepreneur, you can even get a letter from an economist who can confirm the cumulative positive, substantial economic impact your business can have in the particular region or the country as a whole. So really a variety of letters can help prove various aspects of a case. Now, it is important to be selective when you're selecting the experts who are writing your letter. So who is writing the letter? It is important to get letters from leading experts in the field who clearly have decades of experience. We typically add the full-length curriculum vitae, the resume of each expert who is providing the letter, along with the letter. And this is important because it basically becomes the basis of why this testimony is credible. Right. So having letters from leading experts really give more credence to whatever opinion that is, that is given in the letter. So really, you're looking for senior positions, people who have senior positions in leading institutions in your industry. So and another thing that I mentioned within the NIW context, if you can get a letter from an officer in a government organization, government affiliated organization that covers your field, that can be particularly favorable for your case. Now, another question to ask is, how does the individual know you? So we recommend having a mix of what is called independent letters and what is called inner circle expert letters, right? So by inner circle letters, I mean letters from people who you have worked with in the past directly. And those people can speak to your achievements in the past because they have personal knowledge of those achievements, right? So those letters can provide the detail, about your critical roles, about why your work is different, really provide the narrative, the detailed narrative about what you have done and why it makes you extraordinary. Now, independent experts, on the other hand, are people who haven't directly worked with you, but they know you through your work or they know you through your reputation in the industry. And they can provide an independent and objective, proof that your abilities are outstanding in your field or that your work stands to impact the field. And USCIS tends to, trust these letters as a more of an objective source of an evaluation because they're independent from you. So it is good to have a mix of independent and inner circle letters. And what is the content that should be added in those letters, right? So the content of these letters should include a discussion of your work, your recognition, your accomplishments and achievements, and really provide concrete detail on how your work sets you apart from others in your field. And that is, I would say, the key of an extraordinary ability petition. And if you present an extraordinary ability petition with, poorly drafted letters or letters that don't go into enough detail, then really the, petition could be denied because that may not be enough to persuade the USCIS officer about why you are different from, a vast majority of others in the field. And it is a part of the USCIS policy that USCIS does not need to rely on conclusory statements or general statements that don't really provide the specific detail. So it is very important to add enough specificity in the letters to overcome that kind of challenge. All right, so let's talk a little bit about then some strategic questions when you're trying to choose between which category you should apply for, because as we outlined through the presentation, there are a variety of categories that could be applicable to you. So the first question that you should answer is, do you want to stay in the United States temporarily or permanently? And as Kelly mentioned before, the O1A and O1B are non-immigrant visas, well suited for temporary trips in the United States. And for example, if you have work that is lined up for 1 year, then you would get the visa for 1 year, for example. So the O1A, O1B does not give you a permanent basis to stay in the United States. Although if you continue to have extraordinary ability work that is lined up in the future, then really there is no limit on the number of times you can extend or renew the O1A, O1B visa. So that is one option that you can think about. Now, the EB1A and NIW, as I mentioned before, are both green card categories, and they are well suited for people who want to live in the United States permanently. And as we mentioned before, there are some responsibilities that come with being a U.S. permanent resident, right? So there are some limitations on how long you can stay outside the United States if you become a green card holder. There may be, tax implications that you may want to speak to an accountant about. So those priorities need to be considered when you're trying to choose between the categories. Another question you want to think about is, do you have a U.S. employer or agent, or do you want to self-petition? So the O1A and O1B visas, they require either a U.S. employer or a U.S. agent to act as the petitioner for the case. So if you don't have any connection to the United States, then the O1A, O1B may be a difficult category to pursue. Now, it is possible if you're an entrepreneur, right? And if you set up a U.S. corporate entity in the United States, right? That corporate entity could act as your petitioner and provide you the job offer in order to, drive the petition forward. So that is one option that entrepreneurs could take. So really, you don't need like a separate U.S. employer, like a separate, job offer to do that. You can have your, own consultancy, as long as you can show that you have, extraordinary ability work lined up for you. That can be an option you can use. Now, by contrast, both the EB1A and NIW, as I mentioned before, are green card categories that allow the applicant to self-petition for their case. So that means the foreign national, the beneficiary himself or herself, is the petitioner for the case. And you do not need a U.S. agent, you do not need a U.S. entity, you do not need a U.S. job offer. So that can be a significant advantage for some people. Now, the last question that I want to go over is family considerations, right? So for the O1A and O1B, your spouse and minor children under 21 and unmarried can join you to the United States on the O3 dependent visa. And it is possible for a spouse and children to study in the United States on the O3, but unfortunately, work authorization is not available for O3 dependents. By contrast, the EB1A and NIW are both green card options. So your spouse and minor children under 21 and unmarried can apply for green cards alongside you as derivative beneficiaries. And if you are applying for an I-485, which is an adjustment of status, if you already have, valid non-immigrant status in the United States and you're applying to adjust your status to a green card holder, your spouse and children can also apply for I-485s alongside you and your spouse. When they apply for I-485, they can also apply for, work authorization, an EAD card that gives them open work authorization up to the time the I-485 is adjudicated, and travel authorization benefits, which means you can, once your travel authorization is approved, you can use that to make international travels while your I-485 is being adjudicated. So all of these benefits are also available to your dependents. So that can be a significant advantage. All right. So then now let's think a little bit about some considerations that are relevant when you are already on a non-immigrant visa status and when you're considering jumping to a green card, right? So let's get a little bit in more detail. So if you think of the EB1A, right, and then if you're already on an O1A or O1B, one thing to note is that practically the EB1A is looked at with a very stringent eye. So although the regulatory language sounds very similar, really you require a higher standard to qualify for the EB1A as opposed to qualifying for the O1A or O1B, right? So this means that just the fact that you qualify for an O1A or O1B does not mean you automatically qualify for an EB1A. It is, and particularly if you have an O1B, right? Jumping from an O1B to an EB1A can be particularly high jump because, although the O1A and O1B have different ways that they define what is extraordinary ability, for the EB1A, it is the same. It requires that you are one of the small percentage who have reached the very top of their fields. So jumping from an O1A to EB1A, you may want to think about strengthening your profile while you're on the O1B, right? Really gathering high quality evidence that could really push you, to that standard before you apply. So it may really be good to, plan ahead and take several years to really work on that before you apply for the EB1A. Another issue to consider is timing. So if you are on a non-immigrant visa right now, consider how much time is left on your current visa. Because some visas are more difficult to extend or subject to more scrutiny if you have an immigrant petition filed. So one easy example is the TN visa. So if you are on a TN visa, and if you are thinking of applying for an, I-140 for EB2NIW, let's say, right? And if your TN visa is expiring like at the end of the month, right? So it makes sense for you to go ahead and extend or renew the TN visa first before filing the I-140, because once you file the I-140, right? In some cases, you may encounter more challenge or scrutiny when you're trying to renew a TN visa, because filing an I-140 can be taken by some officers as an expression of immigrant intent. So for those kinds of categories, visa categories, where immigrant intent is, scrutinized quite heavily, it could be, important to strategically time your petition such that you would renew the non-immigrant visa first and then file the I-140. Let's talk a little bit about timing issues related to family. If you have children who may also need the green card, the issue of aging out can be important to think about in advance. Consider filing early enough to avoid any issues with, the child aging out of that benefit at 21. All right, so the final topic we will present today is the question that are extraordinary ability categories available for entrepreneurs? And the answer is yes. So let's talk a little bit about 3 points. The first point is that EB1A and NIW are both green card categories that allow for self-petitions. As I mentioned before, there is no need for a separate U.S. job offer. There is no need for a separate U.S. company that will sponsor your job. So both EB1A and NIW are possible green card options for entrepreneurs. The second point to make is that there has been some changes to the NIW adjudication standard under Madhav Dhanisar, which actually have made NIW a much friendlier category for entrepreneurs. And one of the, as an example, one of the things that I mentioned in the criteria, if you can show, that your business project will, end up hiring a high number of U.S. jobs in an economically depressed area, for example, that is a recognized, argument you can use to support national importance. So the matter of Dhanisar explicitly talked about these options, and after that, this category has really opened up to entrepreneurs in a lot, in a more significant way than it had been before. The last point that I will make is that it is possible to apply for an O1A visa as an entrepreneur, as someone with an extraordinary ability in business, provided that you can provide the evidence that qualify you as an extraordinary ability individual per the requirements that we discussed before. Now, it is important that you must have a separate corporate entity in the United States that can act as the petitioner for the case. So you cannot self-petition. So self-petitioning is still not allowed, but you can use your startup to act as the petitioner to drive the petition forward. So that is certainly an option that entrepreneurs can take. All right, so now we have questions and answers. We can get through them one by one. So I'll just take the first one, Kelly. So good afternoon, Jiyae and Kelly. If a Canadian was approved for the EB2 NIW and they subsequently apply for an EB1A because of the backlog, would they lose or jeopardize their approved EB2 NIW if their subsequent EB1A gets denied? And the answer to that is no. So you can have multiple categories of I-140 petitions going on at the same time. So, and I don't know if the EB1A will conflict in any way with the NIW proposed endeavor, but provided that it doesn't, I don't see any problem with filing the second EB1A after the approval of the EB2 NIW. Letter of confirmation by employer. I'll also take this one, Kelly. My employer denied providing any letter to support NIW application. I only have employment offer letters and salary slips. So if you are talking about proving the 5 years of progressive work experience, it can be difficult to just have the offer letter and salary slip because you need to show how your duties have changed over time to include more sophisticated and complex duties and had that evolution in seniority. So it may be difficult, but definitely schedule a consultation if you would like to discuss more on your specific fact pattern.
I can take this one. So someone's asking about pricing. So if you do have questions about pricing, please feel free to reach out to us by email, and we're happy to send you our engagement letter, which outlines all of our fees and services.
All right, I can also take this one. If I have a project for the medical area, but it is not finished yet, can I apply for the EB2 NIW, or do I need to finish the project to apply? So the EB2 NIW is based on a proposed endeavor to the United States. So you need to present what you are planning to do in the United States once your green card is approved. So if you are using the medical project to support your well-positioned prong, for example, in showing that you are well-positioned to advance your proposed endeavor, then it may be beneficial to have that record of impact. But really, yeah, the answer to that question, I would say, depends on what your profile looks like and what will your proposed endeavor look like. But it is important to note that the proposed endeavor is future seeking. So it is based on your planned work in the United States in the future. Kelly, do you want to take that one?
Sure. So someone says, I have 2 bachelor's degrees, a master's, and a doctorate with 20 years of experience in university teaching and research. Can I apply for the EB1A visa? Maybe, it will depend on whether or not you can meet the criteria, right? So having all of those degrees, I think definitely can be helpful. Definitely helps raise your profile. That being said, what you need to meet is the criteria that we've outlined, here, the EB1A criteria. If you're coming for a professorship or something like that, you may want to look into EB1B. I'm not going to go through that. That's outside the scope of this presentation, but that's something else you could consider if you're kind of in academia. All right. I think, Jiyae, do you want to take this next one?
Sure. EB1A applicant has fellow membership in one organization and senior member in IEE. Now, as Kelly mentioned before, the Kazarian analysis looks at both the quantity and quality of the evidence provided and really looks holistically, does that really show someone who has reached the very, very top of their field? So I would say, yeah, just meeting one, criteria for membership, that is certainly not enough. If you don't have any other facts that are supporting your case, if you would like to, discuss your specific facts, definitely feel free to schedule a consultation. We'll be happy to look at your resume together and provide our feedback. back. But yes, just meeting the plain language of one, criteria among the criteria that we discussed does not, mean that you automatically pass the second step of the Khazarian analysis, which looks at holistically all of the evidence put together. Does that show that you have reached the very, very top of your field? I'll take the next one. Can I add my dependents to my NIW application? What benefits are there if approved for them? So if you are the principal applicant and you get approved for the I-140, you have the basis to then, apply for your green card, and your dependents can also apply for the green card when you apply for the green card. So that is the benefit that is given to your dependents. All right. Another one. Canadian citizen.
I can take this
please,
one. If a Canadian citizen has already been approved for an EB2 NIW and enters the US on a TN, can they change consular processing to adjustment of status if they're on the TN visa when it becomes current? So yes, like if you're in the United States and you're on a valid visa that permits adjustment of status and becomes current, sure, you absolutely can go ahead and file your adjustment of status. It's a good idea not to file it quickly after you're entering on the TN, because remember, the TN does require that temporary intent that you intend to, return to your home country. And so, for example, if you enter on the TN and then a week later you file your adjustment of status application, they may feel that, perhaps you weren't truthful at the border. Maybe there's some inconsistencies. So you would want to wait some period of time. As well, something to consider is just if you do have an EB2 NIW approved, getting a TN may be more difficult. An officer, although you can argue that on this particular entry, it's a temporary entry because you do intend to consular process based on the I-140. Some officers still feel that they don't believe it. Either they're not, not believing that you really intend to depart for this entry, or they don't really understand or agree with the nuance that intent is assessed at each entry. So you do want to keep that in mind, that it is a higher risk TN application if you do have an I-140 pending or approved.
All right, so last question that I see here is, if approved for the NIW, how long do I need to wait, I guess, before applying for the green card? So there is a backlog in the EB2 category, and we've seen about a year right now. And this can change because every month the government publishes new, threshold dates for the backlog, and the priority dates also depend on your country of birth. So all of that can be quite complicated. If you schedule a consultation, we'll be happy to tell you. But yeah, what we've been seeing in general as of now is that there is a waiting time of about a year before you can file, your green card application and your priority date becomes current. All right. It sounds like we went through all of the questions. Can a derivative of E2 visa apply for EB2 NIW? Yeah, so there really is no restrictions on who can apply for the EB2 NIW, regardless of your present status. As long as you have, a valid non-immigrant status, you can apply for, the I-485, which is the adjustment of status application once your, EB2 NIW is approved. And yeah, you can apply, you can self-petition for an EB2 NIW, so that can be an option for many different people. All right, so thank you, Kelly, for sharing your expertise, and thank you everyone for your participation. We will close here. Thank you.
Thank you.